Yesterday, the military judge in the trial of Bradley Manning decided not to drop the most serious charge against him, aiding the enemy. He's being tried for leaking classified documents to WikiLeaks, and that aiding the enemy charge, it carries the death penalty, although the government has said that it will pursue life in prison with no chance of parole. Thanks a lot for that. To discuss how to define aiding an enemy and what this might mean for future leakers and the reporters to whom they leak, we're joined by Ben Weisner, Director of ACLU's Speech, Privacy and Technology Project, Kindra Rotunda, Associate Professor of Military and International Law at Chapman University, Kevin Goztola, journalist at Firedog Lake, and Greg Rinckey, who's also a former JAG officer. Kevin, you're at the trial of Bradley Manning right now. Just kick us off. What is the latest?
The latest here is we've had hours of testimony today calling into question Manning's loyalty to America. And I really don't understand why the prosecutors should be allowed to have spent the last hours going over this testimony, mainly because they can't prove that remarks were ever made to a supervisor about whether he was loyal to America. Apparently he had said something about the flag and how he didn't have blind allegiance to the flag, and this was interpreted as something that could suggest that he was disloyal to America, and now it's being raised to question his motive or his state of mind, and it's something the prosecutors want to be able to reference when making their case that Manning would have been someone who would have aided the enemy, that he wouldn't have been an altruistic or idealistic individual.
And what was your reaction yesterday when the aiding the enemy charge was upheld?
Yesterday when the charge was upheld, I basically understood that that was probably what the judge was going to do, because she had quite a range of ability to keep the charge. She just had a lot of leeway in the sense that if she could find that the prosecutors had presented some evidence, then there was a likelihood that that charge was not going to be thrown out, or that she was not going to acquit Manning of the charge. And I think that there's actually reason to do more focus, and I'm sure that Ben will focus on this, which is the fact that we are deliberating over this charge without an intent requirement.
Yeah, clarify that for us.
Perhaps I should clarify that.
Jump in, Ben.
Okay, sure. I think you can think about this trial as presenting two different kinds of charges. There are the general leak charges against Manning, which turn on the nature of the information that he has already confessed to leaking, classified information, national defense information. And then there is this outlier charge, this aiding the enemy charge, which turns on the nature of the entity to whom he leaked it. The aiding the enemy charge does not require that the information leaked be classified or defense information or even sensitive. It prohibits any kind of intercourse with an enemy. And this is the first case in which military prosecutors have ever alleged that someone aided the enemy without also alleging that the person intended to aid the enemy. And that's a critical distinction, because if the military's charge here is that one indirectly aids the enemy by sharing information with the media to which the enemy has access, then that puts at risk of prosecution any kind of unauthorized communication with the media, regardless of whether the information is classified, regardless of whether it's sensitive. That's why I think this charge is not only unnecessary, given Manning's plea, but also unconstitutional and vulnerable on appeal.
Well, it makes every leak subject to this kind of criticism, doesn't it? I mean, every leak in some way can hypothetically help Al-Qaeda if what you're leaking...
This is the problem. The problem is, in the information world, there's no way, information age, there's no way to communicate with the American public without also communicating with the enemy. The government's theory focuses on the enemy as the only audience for this kind of information. But think about how important leaks to the press have been in our democracy just over the last 10 years. Without unauthorized leaks to the press, we would not have known about torture at Abu Ghraib. We would not have known that the Bush administration operated a network of secret prisons where people were rendered and tortured. We would not have known about the Bush administration's initial NSA spying program that was later legalized by Congress. There's so much information that is critical to citizens in a democracy that we get through leaks to the press. The government, with its theory, purports to equate leaks to the press and the public interest with treason. That's what aiding the enemy really is. Not to beat around the bush, aiding the enemy is a disloyalty. It's a treason charge, and it puts all future leakers, all journalists at risk, and threatens to prevent the public from having information that the public should have.
I just want to take a look at the actual letter of the law here. This is a quote from the Uniform Code of Military Justice. This is Section 904, Article 104. It defines aiding the enemy as follows. Any person who, 1, aids or attempts to aid the enemy with arms, ammunition, supplies, money or other things, or 2, without proper authority, knowingly harbours or protects or gives intelligence to or communicates or corresponds with or holds any intercourse with the enemy, either directly or indirectly, shall suffer death or such other punishment as a court-martial or military commission may direct. Kendra, is that why the judge found that in this case there was enough evidence to proceed?
Well, and I want to back up just a minute because it's a lot more nuanced, I think, than what has been presented. First of all, at that stage of the trial, the bar for the prosecution is very low. The judge only has to find that the prosecution has presented some evidence that would support the aiding of the enemy charge in order to allow the charge to move forward. And she decided that. So I just wanted to comment briefly on that because I don't think it necessarily means that the sky is falling. I don't think it necessarily means that this is the end for whistleblowers or that it's going to necessarily impede on investigative journalism. All it means is that the judge has decided to hear additional evidence on the issue, to allow both sides to an opportunity for closing argument on this issue, and that she's going to weigh it in the end. And in the end, the standard is going to be much higher, that she's going to have to decide beyond a reasonable doubt. This is a bench trial, so there's no jury, it's just the judge, but she'll have to decide beyond a reasonable doubt whether or not PFC Bradley Manning aided the enemy. And so there are two very different standards, very different analyses. I do think that the prosecution has a pretty big hill to climb, but I don't think it necessarily means that there is going to be an acquittal or that it's going to in any way whittle away at the whistleblower rights or protections.
And just to clarify, Kendra, the bar that they had to clear in order to have this charge heard, is that the same in a military tribunal as it would be in a civilian court?
Essentially, I mean, the idea is that prosecutors shouldn't be allowed to charge frivolously, and so it's a check on that. So there's some leeway given at the beginning for prosecutors to be able to present evidence supporting their case. But ultimately, defense has the opportunity to say, look, prosecutor hasn't met the standard. They've brought nothing forward, and this is simply frivolous. The defense made that motion. The judge disagreed, and so they're going to both move forward and continue presenting evidence on this case. Another thing I think is important, too, goes to the knowing aspect. I also think that's a little more nuanced. The judge said in her decision, in her oral decision, she said that she relied on a number of things to decide that the case could move forward or that charge could move forward. And one of them is that PFC Manning is a very sophisticated defendant. That was important for her. The prosecutor had brought forward almost 30 witnesses from the intelligence community to talk a little bit about and to testify about the role that the media plays, or rather that the internet plays, what we know about Al-Qaeda and how they get their information, and really importantly, how analysts are trained. Are analysts aware that Al-Qaeda operate and pull information from the internet? And there were a number of witnesses who said, yes, they were. And in fact, the judge also relied on a presentation that PFC Manning himself had given on this topic, warning about the concern of leaks. So she'd looked at that. She'd also looked at the volume of evidence that was leaked, the fact that there were more than 700,000 pieces of evidence that were leaked. So she gave us some insight into this initial ruling. At the end of the case, because it's a bench trial, the judge will issue findings of fact and conclusions of law. And it's then when we'll be able to really look more closely, look behind the rationale of the judge and determine what this really means on a grander scale, or it may be a narrow ruling limited to these facts. So some of that remains to be seen.
Jump in real quick, Ben. I want to get
I just want to say, I think our disagreement is more fundamental than Kendra recognizes. It's our belief that the actual legal standard that the judge is applying here? Is there evidence that PFC Manning knew that information that was placed on the internet would be available to Al-Qaeda is the wrong legal standard? That the correct legal standard, and the only legal standard that makes this charge constitutional, is whether PFC Manning had the specific intent that Al-Qaeda would receive this information. And the reason for that is really clear. You saw the statute, it was put on the screen. It bars any communication directly or indirectly with the enemy. It doesn't require that it be classified. It doesn't require that it be sensitive. You don't need to be sophisticated to know that information that you put on the internet is going to be available to Al-Qaeda. And that's not just PFC Manning giving it to WikiLeaks. That's any one of many thousands of enlisted members of the military who are bloggers. And that's any spokesperson for the Pentagon who stands up at a podium with CNN and Al Jazeera cameras in the room and speaks. The enemy will see all that. So if the government's theory is that all you need is to know that that information will be available to the enemy and you can be convicted of this charge, that's a massively overbroad legal theory, and it would criminalize not just leaks of sensitive information, but really all communication. And the way to rescue the constitutionality of this is to require the government to allege and prove that the defendant intended to aid the enemy. The government hasn't even alleged that. So this charge should have been dismissed before trial, not just after the evidence.
Greg, I think the question, stand by, Kendra, and I will come back to you shortly to respond to that, but I just want to get Greg in. The New Republican in March had an article called The Dangerous Logic of the Bradley Manning Case, in which it wrote, aiding the enemy is a broad and vague offence. In the past, it was used in hardcore cases where somebody handed over information about troop movements directly to someone the collaborator believed to be the enemy, to American POWs collaborating with North Korean captors, or to a German American citizen who was part of a German sabotage team during World War II. Now, we know from Bradley Manning's own words, right? I mean, he has said in his document, he says, the reason why he leaked was because, quote, I believe that if the general public, especially the American public, had access to the information, it could spark a domestic debate on the role of the military and our foreign policy in general as it related to Iraq and Afghanistan. Those strike me as two different motives. Does that matter?
Yeah, absolutely. I think it does. I think Private Manning, some of the comments that he made that he wanted to spark debate, I don't think that's a valid reason, especially since he holds a security clearance. He's an Army enlisted member. The fact that he wanted to spark debate is not going to be a valid reason for him to divulge this information. He was highly trained. In fact, he had given security briefings in regard to the internet and how Al-Qaeda was using the internet. So, and also I think some of the prior examples that you had given us, those are a little bit dated because of the expansion of the internet and just how worldwide everyone gets this information.
But do you not think, so in your opinion, do you need to have a motive? I mean, is there a difference between leaking something with the express intent of stirring up domestic debate within the United States in the knowledge that that information is then going to be available to people around the world because of the nature of the information age that we live in, and on the other hand, someone who goes to Afghanistan or directly communicates with someone in Yemen and provides that information with them with the primary intent of aiding our so-called enemies?
I think intent could clearly come in at a sentencing phase if he gets on a stand or, the evidence comes in to show that he didn't intend for this to go to Al-Qaeda. He was trying to spark internal debate or domestic debate. I don't see it playing very much into the finding of whether or not he's guilty or not of this in this matter.
Interesting. I just want to read a couple of comments that our viewers are leaving online as they watch. Nima says, so if the information leaked lands on the internet, you're helping the enemy? And Brian Penny says, I'd hope military analysts are aware that terrorists use the internet. Kendra, you were trying to jump in there. Go ahead.
I just wanted to clarify, the prosecution has spent an awful lot of time on the aspect of showing what was in the mind of Bradley Manning. They have made attempts to show that he knew how Al-Qaeda operates, that he had particular training in that. They even had one analyst yesterday, although the hearing was closed because it was a DIA analyst. It was highly classified, but presumably to testify a little bit more about what analysts know. So I think in some ways it's a little more narrow than how it's being presented. In this case, you had a specialized defendant, and that was important to the judge. And she said that in her ruling in deciding not to dismiss the charges. It was important to her that the defendant here had extensive training as an intel analyst. And so the prosecution has spent a good bit of time trying to demonstrate that he knew this information could potentially get into the hands of al-Qaeda. I also wanted to just make a brief comment that, leaks within limits are good for our country. There's no question about that. They keep our government accountable. They preserve our democracy. That's very clear. And what we have to determine here, and what the judge is ultimately going to have to determine, is whether or not this falls within those limits or falls outside of those limits.
Kindred,
and realizing that, sorry to
interrupt. I just wanted you to clarify what you were saying earlier, because I'm genuinely confused. The judge is taking into account and saying that it's relevant that Bradley Manning had expertise in the intelligence field because he should have known the impact that this dump of documents could have and the benefit that it could give the enemy. I don't understand what the difference between every person who understands that the internet is a place that people can access from Yemen and Afghanistan and Pakistan and Iraq. What's the additional knowledge that makes his knowledge special?
Well, what was important to the judge was information about what intelligence analysts know about al-Qaeda. For example, there was some information that al-Qaeda specifically goes to WikiLeaks, that they prefer WikiLeaks, that they have requested of their followers to go on and mine through WikiLeaks to try and find information. So that was important to the judge. Again, the bar was very low. I do think the prosecution has an uphill battle. Most of this is circumstantial. Cases can be won on circumstantial evidence, but it does have an uphill battle to get to that beyond a reasonable doubt piece. I'm just saying what was important to the judge did go to this defendant's particular knowledge, access, and the sheer volume, 700,000 pieces of evidence.
If what's important is that this defendant knew that al-Qaeda likes to use WikiLeaks as a source, then if he'd leaked this document dump to the New York Times, would he not have been charged?
Well, the prosecution said he would have been.
Right, yeah, the prosecution.
So I still don't understand what this extra information is. Ben, I don't know, jump in.
Well,
I think the point that we're going back and forth on this, I mean, in this call, we all have different views of how this might be seen, supports my point, which is that the judge simply said, look, there's enough here to further consider
I take your point on that, Kendra, and on the narrow legal point of whether or not the judge should have allowed that charge to stand or not. I think that's the less important part of the conversation than the part of the conversation of whether or not it reasonably constitutes aiding an enemy to leak something for domestic consumption primarily. But Ben, jump in.
Well, I will say this is the first case that I have ever heard of, and I would invite all of the other guests to refute this if it isn't true. It's the first case that's ever been charged by the military under the aiding the enemy provision without a specific allegation in the charges that the defendant intended to aid the enemy. And I still haven't heard Kendra respond to that. Knowledge and intent are two very different things. Of course, an intelligence officer would know that al-Qaeda has access to the internet, just like a 14-year-old child would know that al-Qaeda has access to the internet. Stuff that's put on the internet is available to everyone. What makes an aiding the enemy charge constitutional is both allegation and proof. Not the defendant knew that al-Qaeda might see it, but the defendant intended. And I say this is all unnecessary because there are plenty of other leak charges here that don't require that. There are the Espionage Act charges. There are the charges that Manning has already pled to that have a very different standard that courts have upheld. This is a special charge. This is a charge that is saying not just that somebody gave information that he shouldn't have, but that he communicated with somebody who is our enemy. And that's why this is really, really unprecedented. And what Manning knew is not enough to convict him of this charge.
Kevin, Kevin, sorry, Kendra. Kevin's nodding there, and we lost him for a little bit, so I just want him to jump in. Can you hear me, Kevin?
Well, what I think needs to be put in here, and what I think needs to be put in here, and you can stop me if I'm repeating something that's already been said, but as somebody who's a reporter who's been covering this, I witnessed the defense defend what Manning had done as an act of civil disobedience and make a very, very cogent point about how the way this is being charged takes away that ability of a soldier to take on defying the law and go to jail for defying the law. So what I'm trying to say is that if you released information to the public and that was your stated reason for releasing the information, David Coombs, his lawyer, said that somebody could expect that they would be charged with Espionage Act charges possibly. They could expect that a creative prosecutor would charge someone with exceeding authorized access on their computer and possibly with stealing the information. But no soldier who was engaged in this act would expect to be charged with aiding the enemy. It just doesn't make any logical sense that that person would be guilty of committing such an act, and that person should be able to go to jail for 10, 15, 20 years, however long, as an act of civil disobedience if they believe that it's in the public interest to speak out and share with their fellow Americans what it is they are seeing on the inside.
Soldiers don't have the same rights as all American citizens. I mean, basically, when you raise your hand and you enlist, there's some.
I don't think they got the constitutional rights when they join the military.
They don't drop their constitutional rights, but they don't have the same rights. Civil disobedience, as you're raising, that soldiers don't have the rights to civil disobedience. They don't have the rights to full there's other mechanisms. If they feel that there's violations, they can go to the inspector general, they can go to a JAG officer, but they don't have the same rights.
But Greg, what do you feel the appropriate? I think this is all a matter of extent. I think everyone agrees that that they waive.
And let's just admit that we're equating
rights.
civil disobedience with treason.
Hang on, Kevin. Yeah, I think everyone agrees that that when people join the military, they give up some of their rights. But obviously, the question is, when you leak something and when you do something wrong, isn't the appropriate punishment a court-martial or maybe some jail time? And aren't there? I mean, I almost feel like aiding the enemy is demeaned. The charge of treason is sort of belittled when we apply it to something like this. Greg, I'd just be interested in your thoughts.
I mean, that's definitely an argument to make, is to say that this is watering down the aiding and abetting charge. I think if he's convicted of the charge, there's likely going to be an appeal. And in my opinion, the appeal, depending on the basis of what he's convicted of, there's a good chance that appeal might succeed.
I just want to read out some more comments that are coming through. Tesla's the new BMW says, I believe the treatment of Manning has been deplorable, inhuman and un-American, particularly because of his whistleblowing acts. We Americans are better informed about nefarious and criminal deeds in our name because of his actions and those of Assange and Snowden. And on Twitter, John Schwartz says, the government charging Bradley Manning with aiding the enemy makes a lot more sense when you realise their enemy actually is Americans. Haha. Ben, do you want to wrap us up here? What are your final thoughts about where this is going to go?
Well, I think that this charge was a massive overreach on the part of military prosecutors here. I think it was unnecessary, both because there were other charges that they have prosecuted and because Manning agreed to plead guilty. But I think that this is part of a broader trend. We've seen in other cases the Department of Justice say in briefs that in some ways leaks to the press are more dangerous than selling secrets to the enemy, because if you sell it, only one enemy gets it. But if you publish it, all the enemies get it. Well, in addition to the enemies getting it, the people of the United States get it, and the people of the world get to see it too. And I think that that's something that the government is being a little bit blind to here when it equates leaks to the press in the public interest with treason against the country.
Well, also, there are good leaks and bad leaks in the government's eyes, right? I mean, every time a reporter, you see on the front page of the New York Times something say that 2 government sources have confirmed blah, 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 those are leakers. I mean, the prosecutorial discretion that people hide behind in terms of saying, oh, yes, well, we have the discretion to charge Bradley Manning, but we don't need to charge these other people. I mean, another word for that could be cherry-picking your friends and cherry-picking the criminals who you like and the ones who you don't like, right?
In the late 1970s, the general counsel, the top lawyer for the CIA, testified to Congress that he wasn't even certain that the Espionage Act could be used to prosecute any leakers to the press. At that time, it had never been used that way. He said that if the Espionage Act criminalized leaks to the press, there had been an unprecedented crime wave in Washington going back decades. Now it's more established that the law can be used that way. But as you said, virtually all leaks to the press are not prosecuted. Many, many leaks on a daily basis are authorized by the government for political purposes, for bureaucratic purposes. So what we're really talking about here is a world in which the government selectively prosecutes unauthorized leaks and promotes other leaks. One could argue that it's even more dangerous for a democracy for the government to manage the information environment that way than if it went after all leaks consistently.
Kendra, I'll give you the final word just because we've been piling on against you.
Oh, well, just wanted to, that's okay. Just wanted to point out a couple things. The one is that, again, this is an area that is going to be developed as the law moves forward. A lot of this is a function of now, with all the information on the internet, the age of the information highway, there is a lot of more information that's out there, and it is going to bring these kind of issues to bear. So this is novel, but a lot of it is because of the age in which we live. This case would be much easier if we had Bradley Manning turning over a jump drive to Osama bin Laden and being paid for it. I mean, that's what we typically think of as aiding the enemy. And this case, I think, is very important jurisprudentially. If the judge finds him guilty of aiding the enemy under this collection of facts, it will be interesting. There's no doubt that it will go up on appeal, I would guess, and that the appellate courts will be allowed to now shape and form this a little bit in terms of the reality in which we live. And so I think it could potentially be a very important case. But as we approach it, I think we also want to have a little bit of temperament here, a little bit of restraint, and realizing that the judge has not made a decision, that she's simply hearing evidence on both sides, and we'll see what happens.
Well, if he's convicted of this, then I know many people who've leaked information to me from inside the government who should also be convicted, but I do not want that day to come. But thanks to all four of you for being part of the conversation. Thanks especially to Kevin for hanging out in his car outside the military courthouse and trying to make that connection work. You can let us know what you think about all this, of course, by leaving a comment in the comment well. You can find interesting articles in the resource well. This is HuffPost Live.